13.
You make 13. Code number 13. Make a mention before code number 13.
May I please your lordship? Lordship, I would like to beg for item number 2, respondent 1. By saying item number 2, respondent number 1, on behalf of S. Roy. My senior is out of station, and item number 20, we are for the petitioner. When
Just a second. You are making submission item number 2.
2,
It is a case for mediation identified for sending it before the mediation. What you want to say in that? Whether it is a fit case for mediation?
yes,
Can be.
with the consent of the other
Lordship, I am for item number 2. If it can be referred to mediation,
mediation.
It can be referred to mediation.
but the name of the respondents have not been shown in the cause list. Lordship.
Counsel.
Yes.
And item number 20.
Just a second. Pardon, Mr. You are Mr. Handy.
Mr. KK Handy, Lordship.
Pardon, Mr. KK. Are you a good name?
Adi Hazarika.
You are appearing for S. Roy.
Yes, Lordship.
Appearing on S. Roy. Counsel for the respondent. Case is identified for sending it to mediation, and it is submitted by the counsel. Says that maybe a bit to send it for mediation. In view of this, the raised hereby directed to do the need to send the report for the services for mediation, and High Court Legal Services Authority also hereby directed to appoint a mediator. But parties are accordingly as per your convenience when it can be sent for. The parties may be direct. You have to direct parties.
Yes, parties have to come from Hemati, Lordship.
Hemati.
Lakhimpur, that is why.
So you
15 days
need
time may be given.
15 days.
15 days.
15 days. 26th of February.
Lordship.
26th of February, directing both the parties appear before the registry will also pardon. The registry is hereby directed to reflect the name of the eternal counsel for the
Deeply obliged, Lordship.
Item number 20, we are for petition.
It was in hearing column. So have you taken concept of the other side? Because
Yes,
the other side is most probably the claimant.
We have taken consent. Yeah.
Distributed by with the consent of the other side. And it comes to the budget. After 3 weeks, list after 2 weeks. As donated to it.
Your Lordship. My Lord, this is not fit, Lordship, for mediation. It's the driver had a fake driving license and it was proved by the insurance company. So, Lordship, pen recovery order is required, but that was not given.
Maybe I'm appearing for number 1 and 3.
So as per the appellant, it may not be a fit case. Do you think?
I have to take instruction from my senior.
As per you, it is not fit.
Not fit.
I heard Ms. Chaudhary did not for the appellant. Are you a good name?
Didas, sir.
Didas. You are appealing for whom?
Respondent 1 and 3.
One,
No, which council?
1 and 3. 1 and 3, Lordship. 1 is the claimant and 3 is the,
I'm for the claimant.
it's only one.
1.
One. Who is one for one?
For 1 is the
Majumdar.
Andy.
Andy?
Yeah.
Andy.
Alauddin
The
Ahmed.
case was next one. Case was identified for sending it to mediation, submitted by Mr. Chaudhary Capital. That the law points are involved in this case, where uh, the insurance company has already proved the fake driving license of the driver. This is submitted and send it. Now, at least what is this case?
Order, Lordship.
Order call
Matter may come up for order.
may be listed after 3 weeks in order.
Sir?
After 3 weeks
No.
in order.
Must oblige, Lordship.
May I please?
Yes, what do you
The
want to say in
impact-
item number 3, fit case for when
No, my lord. In fact, we are challenging the order of the tribunal on the basis ground that the tribunal has passed inconsistent order in two cases arising out of same accident. My lord. In one case, the tribunal hold that there is a insurance policy. In the other case, in my case, my lord, tribunal hold that there is no insurance policy. Arising out of the same accident, my lord, two MSC cases were filed. So in our case, my lord, the insurance company were exempted. That is understandable. In fact, my lord, I have taken consent of other side, Mr. S. Roy, my lord. She is out of station for some personal inconvenience. Can it be on 19th of February for hearing, my lord? The hearing took place on many occasions, my lord. 2018 matter, my lord.
we have to check? Because many matters have been fixed in the month of February. He is saying that based on 26th of February.
26, my lord, I have some difficulty. 24 and 26.
March, I think. In that case, it has to be listed on 5th of March.
In a hearing date, my lord?
Yes,
my
yes,
lord.
it is a
Yes,
hearing.
my lord.
Our Mr. P. that done. S- it's not sending it to mediation because they done it Court of MCT and done it member MCT has different views in two cases arising of the same case. When he submitted the case, it's ready for maybe listed. Fine. Considering the submission made by Mr. Majid by the matter of March or
Hearing.
in a hearing.
On 5th of. I'm obliged.
Bishop, this case may be sent for mediation. I'm for the,
You're saying that it may be a fit case for sending it to mediation.
as we have primarily filed the case for quantum, it is.
Only for one.
But the Honor, I had sought instruction from my clients in the morning. It's from Jora. They are from Jora. They said they are expressing their unwillingness to travel to Guwahati for this. So I told them that will be the better option for them. I tried to explain to them that if it is a hearing, again, hearing will take it's 2020 matter. I explained all those things to them, but still they are not willing. Probably the point is that they coming all the way from Jora. Then I'll say just for this, they said that's the thing. So my instruction is that they are not willing to sit in mediation. So I'm handicapped.
Basically, it is on quantum only.
That's I explained to them, but I have to express what the instruction is for my client. I cannot go beyond my client's instruction. So that is I had tried.
Let us try for one because
Yes,
we are the mediation drive in fact.
that's what
And
what
one
can be done is that
intervention.
without
So,
reflecting the thing, if I can explain that the court is inclined to send for mediation, maybe they will come. And probably owner can also explore. This is just out of the thing since these people are coming from outside, these are very low, I mean, they are very low income people, all the way coming from Guwahati, incurs a cost to them. So maybe a VC from their thing for mediation center there and mediation center.
may not be possible because in every room.
No, that's what I'm not saying about this case. So that can be an eventuality in the next mediation drive to make it a more success.
Suggestion where we can record.
So that because
In the next,
they can go there.
actually, in fact, we are having meeting today itself, I think.
Yes.
So we'll
That because that's a suggestion that is because what happens is if they go to Jorhat, if they go to the Jorhat court there, they sit there in that mediation center and there is a so that way they cost is saved. Because these are mostly poor people with a very low income bracket. So again, coming to Guwahati, it's like they have to stay there, here, take a hotel. That's a cost which is a burden to them for a thing which they are already doing. That's my only suggestion.
Somebody mediation woman. Say,
Let it be sent with the, I mean, my thing may not be recorded, just be sent on the.
no, your this the proposal. I find it practically may be possible because now I don't know whether in every mediation room whether there is any
No.
VC facility
No,
or
that's true.
it's probably it's not there.
Yeah.
So
But it can
the
be done.
mediator, yes, it can be. Mediator can also come from the one of the court or any other room
Yeah.
for the same, or your client also may appear from the district office or the judge's office from the Jorhat court itself. That may be one of the option.
Yes.
So we'll place your thing.
And
the-
you know, I'm just placing now, I'm just being out of the thing. What happens is since it's a mediation thing, it's not particularly judicial kind of a thing. Nothing happens, anything that happens within a mediation room is not admissible in any part, any court of law. So the option of appearing through VC through mobile also can be explored because it's just they have to say, yes, I am doing it. Yes, I agree to the proposal. I don't agree to the proposal. Later on, when the proposal is agreed, they can come down and sign the mediation thing. Because if this is agreed, that will be a fruitful thing. So that exploration can also be just a suggestion kind of a thing.
Okay, we'll record your suggestion and the other way. But what will happen? Mediation parties actually both the parties should sit together
Hmm.
and the mediator should I mean talk separately today and once the joint sitting is
Yes.
also there. So these things are there. But yes, in a given circumstances that may be possible as you have suggested. We'll keep your thing there and today's meeting is there.
Deeply.
Otherwise, we are sending this one for mediation. You just spoke. You are Mr.
S. Sharma on behalf of L. Sharma.
Heard Mr. Ashram appearing on behalf of Ms. Alicia and heard Mr. MC the Daniel Council appearing for hearing submission made by the seen that the case is basically on quantum and ends at the case to send it to mediation. The registry will do the intimating the parties and both the parties are accordingly directed to appear before the mediator on as a whole. Yeah, I have to fix a date here. So as per your convenience, will be the date. Suppose if they have to come.
Date may, since they are not agree, any date may be given.
We're listing some matters from this court on 26th of February. So we're listing it on 26th of February.
Oh, deeply obliged.
26th of February, so and so. The state legal services authority will also take necessary steps in appointing the mediator list. Okay, we're listing.
Deeply obliged.
You are for respondent number 2.
I'm for respondent number 1.
Good name? BJ Talukdar. BJ Talukdar appearing on behalf of Mr. D. Das. You're for the respondent number 2. It will be recorded. Nine. Yes, 5. What is your say?
Yeah, my BR as for appellant, my lord.
No, excellent. Is it a fit case for mediation?
Yes, my lord, we are agreed to settle, but opposite party.
Your case is basically on quantum.
Yes, my lord.
Then it can be said yes.
Lordship, actually, one difficulty is that Lordship, this matter was earlier twice it was missed and then again restored. In the meanwhile, we have returned our file to the insurance company. So we do not have the copy of the appeal memo and appointment also from the insurance. So before making any submission, Lordship, they may provide us a copy and we can obtain the instructions. And
Is it
also, Lordship,
possible on your
regarding
part to provide a copy of
Yes, my lord. if
The memo.
I have extra copy, I want to give now.
And Lordship, one more submission, if Lordship kindly peruse the last order. They were directed to obtain instruction regarding if the owner and driver are required in the appeal. So till now, they have not taken any steps.
It was struck out, my lord, because of the trial court, the judgment passed against the opposite respondent, and respondent also satisfied the awarded amount. So in their trial court, they have not any plea that the owner and driver is also liable. So it is not necessary to impede the owner and driver, my lord. The unnecessary.
Lordship, first letter of
Expenditure
instruction,
required.
Lordship. Not making any submission. That will be my humble prayer.
Mr. Pierre Dunstable. Mr.
SP Sharma, Lordship.
SP Sharma. The respondent. Submitted by Mr. Das that it is the case it may be a fit case for sending it. However, it's submitted by Mr. Sharma that the presently the brief is not with the respondents. Accordingly, he submitted that he has to take instructions from the company, and in the meantime, the applicant may be asked to provide an extra copy of the memo to take the proper instructions. In view of this, the applicant is hereby asked to provide an extra copy of the memo during the proceeding, and considering the submission made by the said the matter is not sent before mediation. The accordingly may be fixed in order column. 2 weeks as an edit. We're listing it in order column after 2 weeks, and on that day only you make your submission in regards to striking out the name of the owner and driver.
Yes, on 21st February, can it be fixed on that day? I have-
Uh,
Lordship,
may not
from
be possible.
21st, 27, Lordship, some difficulties there. So either before that or after that, 21st to 27 of February. Will be difficult. I will have.
No, date may not be fixed. After 2 weeks, we are listing.
Yes.
Obliged.
Item number 6.
6 also you are appealing at.
No, my lord, this case is, my lord, not for enhancement. My lord,
Any law point is involved here?
yes, my lord, the notice was served, my lord, and
No, law, whether any law point is involved here.
yes,
Law point.
yes, my lord. That, my lord, initially in trial court, the MSCT case was dismissed for default. So thereafter, due to the attack, it is the case of the COVID-19 period. So then after we had filed an restoration petition along with delay condon petition. My lord, delay condon petition was allowed, but restoration petition was not allowed. So that's on that ground we have filed the case. And my lord, notice to the respondent number 1, it was last they are directed to take a substitute manner by paper publication. That was done, and affidavit is also filed. So my lord, that the order has to be filed to restore the MSCT case and direction to the trial court to proceed the MSCT case accordingly and on merits, my lord.
Where you have filed your affidavit?
My lord, on the last occasions, last day, I have filed the case, my lord.
Acha, affidavit is filed.
Yes, ma'am. That's also, it is not for enhancement, my lord. The order may be passed to, as a notice is served.
And who is the executive engineer PWD? Have we?
This is
Because the office note says that the paper publication was only in respect of respond number 1.
yes, as per direction by this court.
And now what about 2?
About 2, it was notice was served.
Served.
Yes, my lord.
Why it is an appeal?
Appeal, my lord, because of the
Is it a case of appeal?
yes, my lord, because of the
Why?
trial court has dismissed my case and I have filed a restoration petition along with delay condon petition.
But now your petition, this petition or appeal, whatever it is It is only against the order of
Yes.
section of your restoration.
Yes.
It's an appeal.
Yes.
Why it is an appeal? You made submission in that regard on the next week.
My lord, this is the trial
But
court.
Mr. Biatas did not consider the appellate. From the office note as well as the order passed by this court, it is seen that the respondent notice under respondent number 2 is duly served. However, the notice to the respondent number 1 is served through paper publication. An affidavit is also filed to that regard. As per the assumption made by Biatas, the case is not fit for mediation. And at the same time, it is seen that the hearing is need, the matter is also need to be heard on the point of mediation. This matter accordingly after 3 weeks as an edit by the registrar. It is to be heard for the maintainability also. Huh?
Yes, my lord.
It doesn't seem that it is a case of appeal.
My lord, can it be fixed on 21?
We are not fixing 3 weeks after 3.
Yes.
Yes, it is a fit case, Mr. Prince.
With quantum, my lord,
It is only for quantum.
Yes.
Can be, I think.
can be, my lord.
And you are appealing for whom?
Claimant respondent.
Claimant.
As per the order dated 10/12/2025,
Huh.
in the IA,
Huh.
they were
I.
applicant was required to deposit 30%. Till that they have not deposited.
It is being processed, my lord. Some time may be required, may be granted, but 2 weeks at least. Of course, it is 10/12/25 order, my lord. It is not been complied, my lord. It is being processed. I have come to know yesterday only. It is being processed.
Two things are here.
Yes.
One, that they have not complied with, I can understand. And the second, that if suppose case is sent for mediation, if somehow it is settled, then in one
is-
time only
Yes,
entire
it is
matter will be
that can
settled.
be.
So let us
We are
try
ready.
once,
We are ready.
see.
We are ready.
Our Mr. T. Khalid, the learned counsel for the applicant, also part of the video, the learned counsel appearing for the claimant respondent. This submitted by Mr. Kalita as well as Mr. Neo that matter may be sent for mediation as it is basically on the quantum. However, it is submitted by Mr. Neo that they have not complied with the order dated 10/12/2025 passed by this court directing the appellant to deposit 30% of the awarded amount. But considering the nature of the case, this court is of opinion that matter may be sent for mediation and which may be finally settled before the mediation. Let the matter be accordingly listed before mediation.
My lord, I have a prayer. If my learned friend agrees, matter may be sent for Lok Adalat, my lord, because they are reviewing the files, the insurance company. So as a whole, my lord, the matter may be can be placed before Lok Adalat, if possible, my lord. Instead of referring to mediation.
Next local
14.3,
14.3.
14.3. If it is possible, my lord.
However, it is submitted by Mr. Kalita that the matter may be sent for settlement before the local alert, which is to be held on 14th of March 2026. 2026, considering the submission made by Planet Council for the appellant, let the matter be listed before local alert on 14th. Please to be
Public.
Oh, it is not yet anyone.
Yes, my lord. May I please?
Delay is not yet condoned, na?
No.
So let the delay be condoned.
Yes.
Thereafter only it can be. How many days delay there?
75 days.
75 days.
75 days.
You are for the claimant respondent?
Yes, my lord.
Do you have any objection? Sir?
My lord, I have no objection to delay conduct, but subject to the 50% deposit.
No, it is not yet registered. It is only for condonation. After registering the appeal, you may make your submission in that.
Oh.
When it is will be
My lord,
registered.
let the matter be registered. Usual
No, let
process.
the matter be registered. No, we have to pass an order for
Yes,
raid.
yes, ma'am.
So where it we have the grounds cited in which para?
Para
your
4,
delay?
my lord.
Para 4.
Para 4. The previous councils haven't informed on time to the applicant. Due to that delay, they couldn't file or register the case on time.
So you are not the company, na?
No,
Who are you in fact?
I am
You are
the
the owner.
Right.
So the learned member MSCT is directed to satisfy the award by the owner only.
the entire.
You are Mr.
And Gogoi on behalf of M. Saranya.
Mr. M. Gogoi appearing on behalf of Mr. M.
My
Saranya.
lord, N.
M. Saranya.
And on
Oh.
behalf of M. Saranya, I am N. Gogoi.
Acha, N. Gogoi. Mr. N. Gogoi appearing on behalf of Mr. M. Saranya, the counsel for the applicant appellate, and also Mr. P.R. Das, the learned counsel appearing for the payment response. The matter was identified for sending it to mediation, but it is seen that the case is not yet registered and numbered due to delay in preferring the appeal. Next paragraph. This interlocutory application has been filed under Section 5 of the Limitation Act for a condonation of delay of 75 days in preferring the appeal against the judgment and order dated 10/01/2025 passed by learned member MSCT number 1, Kamrup M, Guwahati in MSC case number 791 of the 2020. Next paragraph is submitted by Mr. Gogoi that the owner is the appellant could not prefer the appeal within time as he came to know about the judgment only subsequently only on 19/5/2025 and thereafter only the appellant made a contact with the council, and then the memo of appeal has been prepared, for which there was a delay of 75 days in preparing the same. However, it should also be submitted further that there is no intentional laches or negligence on the part of the appellant, and it is only due to fault of the NK's counsel she could not file the appeal within time. Next, Mr. Das, the learned counsel appealing for the respondent raised no objection and submitted that the claimant respondent has no objection if delay of 75 days is conducted. Next, considering this submission made by learned counsel and also considering the grounds mentioned in the petition, which are considered to be reasonable and justified ground, and also for the ends of justice, the present interlocutory application is allowed by condoning the delay of 75 days in preferring the connected. Next the registry is accordingly directed to register and number the connected and then to list it.
My lord, there is another analogous case.
Ever with above observation instance.
My lord, there is another analogous case arising out of the incident. Claimant is different. That's I number 3512/25. That may be plugged together.
So your name, but place is not yet numbered. How?
Obliged.
In this case, Lordship, I have
One.
filed this MSc appeal on the quantum ground, but Lordship, and there is a delay of 150 days, Lordship.
150 days.
Yes, Lordship. And I am
Here also you are appealing for
Yes,
1 to 4.
Yes.
One.
Where is you have cited your grounds?
in prayer number 4, Lordship.
Yes, basically what is the ground?
Basically, Lordship, that conducting council, Lordship, where submitted the judgment on 3/2022, the branch manager, Lordship, on lately, Lordship. Subsequently, Lordship, that the record is misplaced, Lordship. That's why they have not taken steps, Lordship. In the detail, Shipsagar branch, Lordship. After getting the record, Lordship, they have sent it at the regional office, Lordship, Bhangagar, Guwahati, Lordship. And according to there is a delay of 150 days in filing this test.
Yes, Mr. Das, what you want to submit here?
No objection.
RMS, it has found with Learned Council appealing for the applicant starting to appear at the same order. So and so. The case is this case is identified for sending it to mediation, but it is seen that the case not yet registered as the delay of condemnation delay is yet to be condemned for registering the connected application. Next paragraph is an application section 5 limitation for condonation of delay of 150 days in preparing the appeal against the judgment and award dated 30/04/2025 passed by the learned member MSCT number 1 Sipsagar in MSc case number 39 oblique. Next right is submitted by MS Burma that a company came to know about the judgment only on 11/3/2025 from from their engaged counsel, and thereafter to during and thereafter there was a delay for observing the required formalities and required formalities. In a later stage, the regional office had received the judgment and other relevant documents, and thereafter the case was prepared, and hence the delay of that, and hence there was a delay of 150 days in preparing. However, there is no intentional laches or negligence on the part of the appellant. Mr. P.R. Das, the learned counsel for the respondent claimants, submitted that he has no objection if the delay of 150 days is confirmed. But hearing submission made the students during observing the official formality. 150 days to okay, we are disposing the IA with direction to the registry to register and number the connected app.
Problem.
In this case, my lord, I am appearing on behalf of respondent number 3 and 4, my lord.
Respondent 3 and 4.
But my lord, copy has not been served, my lord. IA copy has not been served upon me. Both the IA, my lord.
And what was the IA? The IA number 3784.
IA number 3784 and one IA number 481.
2 IAs are there.
Two IA.
May it please your lordship. Lordship, we are for the appellant in this case. This matter cannot be sent to the mediation center for settlement. Lordship. Two IAs, they have filed an IA for withdrawal of the stay amount, which we have deposited. And we have filed this IA 3784.
This is filed by you.
Yes, Lordship.
Okay.
This is affidavit in opposition, Lordship.
Regarding the prayer filed
For
by them for withdrawal.
Yes, Lordship.
We have to hear those both sides.
My lord, I have filed this IA for direction to deposit the 50% from the awarded amount.
We have not deposited yet.
This is the IA for direction to deposit 50% from the
No,
awarded.
what is the IA for? 3784?
3784 is the affidavit in opposition, Lordship. Hmm.
2 lakh. IA 48.
No, no, 3450. Oh, sorry. No.
The claimants have filed an IA praying for depositing 50% of the awarded amount. And we have filed an IA 3784 objecting that prayer, Lordship. Because 50% cannot be deposited in this case.
No, but IA 481 was filed by you. IA 481,
481 was filed by us.
that is for stay and it has already
It's
been
for
passed.
stay without any deposit, Lordship.
And IA for 3784 is filed for direction to the respondent to appellant respondent to deposit the 50% from the awarded amount. আপোনালোকে 481 ফাইল কৰিব।
Stay হয় stay পিছত আপনি যোনটো আই ফাইল কৰিছে তাৰ আমি এইটো ৰিপ্লাই দিছো 3784 তাৰ আই কি নম্বৰ
3784 এ নহয়। এইটোত আপুনি ৰিপ্লাই দিছে। 3784 টো মই ফাইল কৰিছো আপুনি ৰিপ্লাই দিয়ে।
3784 is filed by the claimant.
Claimant,
Yes, ma'am.
yes, Lordship.
আৰু কিবা আই আছে? One more আই is there?
And
এইটো আই নেকি? নাই। এইটো তাত আছে।
we have filed this affidavit in opposition in this IA 3784 itself.
Oh, itself. I mean, why it cannot be deposited? Is there any ground?
Yes, Lordship. Lordship, in this case, two vehicles were involved.
Acha.
One was a scooty insured by us, and the other vehicle was owned by respondent number 4. The claimant has claimed all the allegation of dress and negligence was against the vehicle owned by respondent number 4. Learned member also came to the conclusion that the vehicle owned by respondent number 4 was responsible for causing the accident. But erroneously, learned member came to the presumption that the vehicle owned by respondent number 4 was insured by us. Lordship. There was no allegation regarding our vehicle, the vehicle insured by us. It was a scooty in which the deceased was riding himself.
My lord, we will
You also made responsible for payment.
We were not made responsible, but at last, the claim compensation was settled upon us.
Or instead of respondent number 4.
Yes, Lordship.
My lord, we will file a bond. Kindly allow my
We cannot pass this order today itself. It needs a hearing, I think.
insurance is there, my lord.
Otherwise, we have received the case record also.
Yes, Lordship. Then Lordship, a short date may be given and a matter may be fixed for hearing. Everything is ready in this case.
Mr. Pierre does done it for the applicant respondent. Seems like that done it for the respondent insurance company and Mr. P.S. Parasati, the press counsel appearing for the GM.
Okay.
Also heard both the parties on IA number IA civil 481. hearing the submission made by Council Bogos, is seen that the case is not fit for sending it to mediation and mediation and mediation. In view of this, let the matter be listed in order. We are listing it in order column so that it can be fixed for evidence. I
Yeah.
mean, here
Yes.
in the order column. We can give you 1 week, but after 1 week, you cannot fix a date. After 1 week can be passed,
Yes,
but date fixing is may not be
It's-
possible. List matter accordingly after 1 week as on a date to be fixed by the registry in order. We're listing it in order column so that it can be
It's by
next maybe fixed for here. Now see 50% you have already submitted the 50% is the, but they are saying that they are not at all liable
Liable,
for
yes.
the payment. Rather it may be the respond number 3
Four.
or 4
yes, Lordship.
who may be responsible for the accident and the liable for the payment.
Yes.
So that may be decided only on hearing the entire case. In fact,
Yep.
otherwise 50% that may not be decided appropriately. So entire matter has to be fixed for the hearing.
Here,
So we are listing it after 1 week so that it can be fixed for hearing.
just
Obliged, Lordship.
This is lordship. My lord, here in this case, my lord, can purpose called for, my lord, earlier bail was rejected. On the ground that the two vital witnesses were not examined, now examined, my lord. And we have also annexed in the petition, and there's implicated no materials against us, my lord. We have the certified copy, my lord.
Certificate copy you have annexed here.
My lord.
The certificate copies you have annexed along with the petition.
Yes, my lord. I have not, and this, my lord, we have the copy, my lord.
PW 3 and 4, those are not vital witnesses. Those. We cannot say that those are vital witnesses. Those. So, because Lordship, I'm since the very beginning, I'm trying to searching the searching Lordship. But Lordship, that search is not available with the case record that I am searching.
But these one,
This will
while
any
rejecting,
logic, because
while
it-
rejecting the earlier bail application in para 8 of the order, the lordship has said that one Pradeep Shah is the vital witnesses and he was not examined, yet to be examined. On that ground, the earlier bail was rejected.
Which para? Para?
My lord, para
No,
8,
no, I mean, sorry, page number.
my lord, it pays 22. 22, my lord, in my additional affidavit, lordship will find in the report. Additional affidavit,
Yes, I have. So that order was on 10/5/2024.
my lord. 10/5/2024. Para 8, my lord, lordship has specifically mentioned. Hmm?
And school
That's so.
problem.
No materials, my lord. His brother was also examined as PW5. He has also says that no materials, my lord. So, my lord, both the persons are in custody for about 3 years, my lord. One is from February 2023, other one is from March 2020.
How many, as a whole, how many witnesses are cited before such?
My lord, as per these judgment, my lord, your lordship has recorded that there are 9 witnesses.
9.
Out of 9, 4 are witnesses or police witness. 4 are police witness and the private witnesses are all examined, my lord, now. Earlier it was 3 were examined, now 2, so 5 has been examined. Only police witnesses are remaining, my lord. That part has been recorded in para 4 of the earlier order.
ওটা ডিসাইড করি করি নেক্সট নম্বর প্রবলেম হতে হইছে সার্টিফিকেট নেক্সট করি বলে
Trial চলে
you
যায়।
know
Trial
দরকার না তার কাছে যখন টেস্ট করি তার বিষয়টা আমরা আরাম করতে পারি After filing of search sheet, lordship, the seeking bail, search sheet is very important document. That is not an that is the
No, but
difficulty.
he may not annex, but whether it is not
That
available in
also
the
not
case
come,
account.
lordship.
Why?
গতিকে চাৰ্জশ্বিট চাৰ্জশ্বিট আপোনাৰ লগত নাই।
Just করি দিতে পারি। Yeah, lordship, the two independent witnesses, lordship, that is PDP member. One that has been examined, and lordship will see lordship may kindly peruse the examination of their examination, lordship. And they have actually they have implicated this person, lordship. And because while he was when you sent to that place of occurrence, that these persons, two persons were present along with the police personnel.
From where you are saying? From which groups?
This is
I mean,
PW
evidence.
lordship. This is PW lordship.
PW?
PW 1 and 2 lords. So lordship, as but offense involved is an heinous offense, and then the accused persons after committing that offense, he was fled to West Bengal, and this person was arrested from West Bengal after a rigorous search. So lordship, at this stage, if he is being enlarged on bail, lordship, he may again flee away. There is every possibility because lordship, after committing the offense, he was flee away to the West Bengal, and subsequently after several attempts, he could be arrested, and the offense, nature of offense, and when in that his acquisition is to some extent proved, lordship, because lordship PW 1 and PW 2, lordship may kindly peruse. Then lordship, there is every possibility of conviction, lordship. And in that case, lordship, if conviction is made, and he will be clear, lordship, after if he is being enlarged on bail.
Well, Lordship has earlier examined the PW 1, 2, 3. Then my Lordship came to a conclusion that 4 is a vital witness. He has not been yet to be examined. That witness has been examined, my Lord, and that witness says that no materials. My Lord, what more, my Lord? How, my Lord, is languishing in jail, my Lord, since my Lord, 2023 February and March. Unnecessary delaying, my Lord.
Because lordship,
And
how person has been killed, lordship, that has to be looked into, lordship. He was because by strengthening his throat, he was killed. Thereafter, he was burned. He was set fire. Thereafter, lordship, this person fell away. So lordship, and lordship, at this stage, lordship, for the purpose of bail, lordship may not go into the entire evidences. What is implication? What more implications are there? Simply emphasis whether any case is made out against him or not, lordship. Whether there is possibilities of conviction is not or not, lordship. That lordship may kindly go through. And from perusing the PW 1 and PW 2, that may come up. That lordship, there is he have been implicated. His implications are there. He may be convicted. To what extent that court will decide. He will be convicted, but his conviction may be there. And when there is a possibility of conviction, and when once person is after committing the offense, he is free away, and he went to the West Bengal. Now where he will go, we do not know. So it is very difficult. It will be very difficult for the prosecution also to for him again. After such an heinous offense, it is not a simple murder. Or after a murder, he has been set fire, everything, lordship. So Lordship, at this stage, Lordship, this bail may not be granted.
My lord,
Though Lordship, 4 witnesses,
No.
5 witnesses
There is
examined,
no
yet-
materials-
Yet 4 witnesses
no
are-
materials at all to, my lord, to implicate them, my lord. Where is the chance of, my lord, conviction, my lord? Chance of conviction is totally bleak, my lord. Lordship has seen the earlier witnesses, PW 1, 2, 3, and Lordship has only rejected earlier bail application on the ground that the vital witness is PW 4 that has not been examined. That has been examined, no materials, my lord.
But Mr. S. Sikka, the learned counsel for the, sorry, AR Sikka, the learned counsel for the, also had Mr. B. Lawford, the learned additional PP, appearing on behalf of the- This is an application under section so in connection with so. This record, can copy of the DCR will receive HTC. It is submitted by Mr. Sikka, the learned counsel for the petitioners, that these two petitioners are in custody for about 3 years. One is in custody for since February 2023, and other one is in custody since March 2023. Their bail application was earlier rejected after perusal of the case record, only considering the some of the vital witnesses are yet to be examined by the court. But after passing of the earlier order, the learned trial court below had already examined two vital witnesses, that is the PW4 and PW. Thus, out of 9 cited witnesses, the prosecution has examined 5 numbers of witnesses. Only the official witnesses are yet to be examined. Thus, there cannot be any chance for tampering with the witnesses, as all the independent witnesses have already been examined. Mr. Sikdar further submitted that there is no incremental materials in the evidence of PW, and thus the chance of conviction is also very big in the present case, even if the accused petition and the chance of conviction is also very big in the present case. Mr. Sikdar further submitted that petitioners are a local person and they are the permanent resident of their address locality, and hence there is no chance of absconding if accused petitioners are released on bail. Rather, they will provide the sufficient surety for the bail. Next, Mr. Lawford, the learned additional PP submitted in this regard that that 5 numbers of witnesses are already examined by the prosecution, and the PW1 and 2 had sufficiently implicated the present accused petitioners, and they also describe as to how the deceased was brutally killed, and even after committing the murder, the body of the deceased was also burned by setting fire. He further submitted that after committing this said crime, both the petitioners were cleared away to West Bengal, and after lots of endeavor, the police personnel, the police could be the petitioners could be arrested from the state of West Bengal, and hence the probability of absconding of these two petitioners cannot be denied at this stage if they are granted with bail, and their procurement of their attendance will also not be possible for trial of the case. Mr. Lawford further submitted that considering the nature of the allegation and also considering the fact that a person was brutally killed by these petitioners, the bail petition, bail prayer for these two petitions may not be considered. Okay, I'll peruse the record. I'll just record it your submit.
On last order, also, Lordship, in para number 12, Lordship had also mentioned, observed all these things. Not only that, Lordship, after the evidence of 3 and 4 and 5, this will be granted. That is not there, Lordship. That vital witness is yet to be examined. That is there. And thereafter, Lordship has also recorded that all these probabilities that he may explain something again. Lordship. Everything is there, Lordship. And it is on fair to enforce.
Okay, I'll pass the order. I recorded your submission.
My lord, they have not paid here. They have the residence in West Bengal also, in the bordering area, my lord. And they have the visiting terms because they are in this place also. They have the business there.
Business.
Yes, my lord.
May I report? Lordship, in this case, Lordship, the opposite parties file a titles with Lordship, and thereafter, Lordship, after filing of the WS, Lordship, the petitioners filed the counterclaim, Lordship. And this counterclaim has been rejected by the interim order. Lordship, order is page 93. Page 93. Mary, Lord.
Which page you're saying?
Page 93.
93.
93.
Yes.
The instant which case is registered against petition number 7 filed by the defendants, praying for granting leave to counter claim at a belated stage.
So at the time of filing your WS, you have not filed it.
They have filed after filing of the WS.
What they have filed?
After filing of
You are the defendant originally?
defendant.
Achha.
Yes. And the grounds of rejection, Lordship, in para, Lordship, from 10, Lord, para 10, page 95 of this order into order, Lordship. The learned advocate for the plaintiff's opposite party submitted in case of the effect court held that the defendant cannot be permitted to file counterclaim after the issue of claim and after the suit has proceeded substantially, and that it would defeat the cause of justice and to be detrimental to the principles of speedy justice as mentioned in the objects and reason for the particular amendment of the Code of Civil Procedure. I have perused the above decision in view of the submission of the learned advocate for the plaintiff, and I find that the effect could have had discussed in detail regarding filing of counterclaim at a belated stage, and it is specifically held that in filing of counterclaim there is no restriction as to time, but the Code of Civil Procedure prescribes the restriction as to cause of action. Order specifically provided that the counterclaim against the claim of the plaintiff may be filed in respect of cause of action according to the defense against the plaintiff either before or after filing of the suit. But before the defendant has delivered his defense or before the time limit for delivering his defense has expired, learned advocate for the defendants and submitted that the defendants have not filed their evidence in the instant suit, and hence it can be said that they have not delivered their defense, and as such cause of action accrued on offer is well within the time limit prescribed. In this aspect, I do not agree with the learned advocate of the defendant petitioner that filing of evidence means evidence of defense. Delivery of defense, as mentioned in Order 8 Rule 6A of the Code of Civil Procedure, is filing of written statement and not defense evidence. Thus, cause of action for filing of counterclaim must occur prior to filing of the written statement by the defendant, and there admittedly the defendant have filed their written statement on 25/1/2024, and the cause of action of for filing of counterclaim accrued on 27/4/2024, and thus the cause of action accrued in the instance which after delivering of evidence defense by the defendants, the plaintiff. Moreover, as held by the Apex Court, Supreme Court of India in case of Pensor, the Honorable Apex Court has listed some factors which are to be considered while considering the. So this is the factors, Lordship, and thus, Lordship, it is seen that by the above judgment, the Apex Court has specifically held that in any case, counterclaim may not be accepted after framing of issue, and they are here in the instance with the issues being framed on 26 to 2024. I am of the considered opinion that filing of counterclaim on 26/7/2024 cannot be accepted. So on this ground, it was not accepted. Other part of my notice, the count, it is a concept, misconcept of fact lottery because in the counterclaim, there are two stage of lordship cause of action. I have stated in my rounds of page 12B lordship, paragraph B lordship. In the counterclaim lordship, your lordship will find counterclaim is page 86. Page 86. And this schedule lordship kindly peruse the schedule, page 90 lordship, schedule 1. Here, district Hailakandi PS Karlikola, Moja, so land measuring an area of 22 bigha, 14 kata, 2 chota, 10 konda land which is bounded by. So this land lordship, 22 bighas of land which is included by the plaintiff in their plaint lordship, the plaint of the plaintiff is page 26. And they included in this, they are saying that these lands are their partial land. So plaint is page 26, lordship, and their claim is lordship, page 28, para 3. The father of defendant that is had again during his lifetime another 22 biggest 15 kata 2 lesser 10 gonda land in various stocks of good patta from one side to the so they have included this entire land lordship in their lordship plane. So the cause of action, this part of cause of action occurred at the time of filing of the claim by the defendant. The title. And the second part is lordship I have mentioned in what is mentioned in the MP order is that on 27 paragraph C lordship, page 13 I have mentioned lordship.
Paragraph C, page?
Page 13 lordship. 1 page. The opposite part is 1, 2, and 3 on 27/4/2024 by making criminal trespass forcibly enter into a part of the counterclaim dwell land covered by the said two dags and constructed a kacha house with the materials of an old kacha house and started plantation of various trees and also have been trying to occupy more land from said dags and have been disturbing the petitioners in maintaining their peaceful position and enjoyment. For which to restrain the opposite party must also from their illegal activities and act of land grabbing, the petitioners are required to include this act in their counterclaim and accordingly describe the same also as counter cause of action, which is interlinked with the first part of cause of action for the counterclaim. So in the impugn order lordship, only that part has been mentioned lordship, and accordingly it is shown that lordship the cause of action after filing of the receipt, WS lordship, and lordship another one judgment is there lordship affects to lordship. Where is lordship? It is stated that lordship the appraisal held that the counterclaim can be accepted even up at the time of evidence. Paragraph 10, lordship. Paragraph 10, lordship. It is quite apparent from the actual position noticed here is above that after the issues were framed on 18/10/1993, the counterclaim was filed by the appellants before the court by defendant number 3 and 4 before the trial court almost 2.5 years after framing of the having given our thoughtful consideration to the provisions relating to the filing of counterclaim, we are satisfied that there was no justification whatsoever for the High Court have declined the appellant before this court from filing this counterclaim on 17/6/1996, specifically because it is not a matter of disclosure the cause of action on the basis of which the counterclaim was filed by defendant number 3 and 4 that would before their written statement was filed. But in the present case, the respondent plaintiff's evidence was still being recorded by the trial court when the counterclaim was filed. It was also not been shown to us that any prejudice would be caused to the respondent plaintiff before the trial court if the counterclaim was to be adjudicated upon, along with the main suit. We are of the view that no serious injustice or irreparable loss expressed in paragraph would be suffered by the respondent plaintiff in this case. For the reasons recorded herein above, we have satisfied the impugned order passed by the High Court and restored the order passed by the here Lordship High Court accepted the counterclaim and High Court Lordship declined Lordship. Even Lordship in case of Lordship in the stage of Lordship recording of evidence Lordship counterclaim can be accepted. But the condition is that the cause of action should be assured before filing of the written statement. Here, in my petition, Lordship, I have stated, Lordship, the counterclaim, Lordship, page 86 is the counterclaim. In entire counterclaim, the main issue is, Lordship, the entire land, it is the 22 because of land, which was included by the respondent's Lordship, as a plaintiff's Lordship, in their plain Lordship, saying that these lands are their partial land. So my respectful submission is that Lordship,
As per your counterclaim, what is your quantity of land?
Lordship, land is
You are saying that 22 bighas have
20
already been stated by the
Lordship,
plaintiff claiming their purchase land. So your land is?
Lordship, actually, I have stated in my petition, Lordship, kindly bear with for a moment. What they have done, Lordship, in the plain, they have mentioned, Lordship, there is no boundary, Lordship. In their plain, there is no boundary. They have mentioned lots of log numbers, Lordship. And in these log numbers, more than 100 bighas of lands are included there. And within that Lordship, our land is 22 bighas.
Your land is 22 bighas.
Yes, Lordship, because
That's
I have
insane.
stated, Lordship, they actually in this Dags and Pattas, Lordship, they do not have any land.
No, that will come later on. I'm
Yes.
saying just you are saying that 22 bighas of land has been mentioned in the plaint.
Plain land.
So what is your land? What is the quantity of your land?
My land is, Lordship, I have Lordship,
You're claiming
my
the
counterclaim
right.
is that the entire 22 bighas, our land, they have included falsely in their claim, Lord. False claim there. They have falsely claimed, Lord.
So in their plan, what was the quantity of land they have claimed?
In their plain, Lordship, plaint is page 17. I have an echo. Their plain, Lordship, there are schedule 1, where Lordship cover an area of 7 bighas, 12 kata. Then Lordship schedule 2, here is Lordship 22 bigha, 4 kata. So this 22 bighas is our land, not 7 bighas. In their plain, Lordship, they have in one schedule 7 bighas and another schedule 22 bighas. We are claiming this 22 bighas.
You're claiming this 22 bighas on what strength?
as our purchase land.
purchase them.
Okay. So my respect for there is the lordship. Kindly at this stage, lordship, the counter claim may be accepted, lordship. Otherwise, lordship, the petitioners may be remedial as well. Yes. Oh.
Yes.
May I please, your lordship? My lord, it is apparent from the counterclaim, page 89 itself. Though my pen is now submitting on the merit is the right of the entire schedule, my schedule land. But in the page number 89, the cause of action. The cause of action, as mentioned, is arose on 27/4/24, paragraph 5, page number 89.
Paragraph 9,
Paragraph 5 of the WS, page 89. Sorry,
89.
counterclaim, page 89.
89. Para 9.
Para 5, my lord. Very fast line.
Acha, para.
Page 8. And all other things that have been mentioned, the counterclaim is already in the
So as per them, the cause of action for the counterclaim erosions
27/4,
27/4.
2024. Since the date of criminal trespass, on that date, it is claimed that we have the plaintiff trespassed the plaintiff constructed kacha house, so materials, old kacha house over part of so counterclaim schedule land by plaintiff under schedule 1, described in schedule 2, and thereafter started plantation, betel nut trees, lemon trees, coconuts, so started pakka building construction about the part so that the residence of the parties located in location of the counterclaim schedule land and cause of action for the. So this is the paragraph 5 is the cause of action. Other is the regarding jurisdiction. So the law is clear in this issue. In the latest judgment of 25/9/2025 of the Honorable Apex Court, I will admit that though the limit is there, before filing the defense of the my lord defendant, for which I will read the order 8 rule 6A for a moment. Order 8 rule 6A, my lord, provides a defendant in a suit may, in addition to his right to pleading of set off under rule 6 set up by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action accruing to the defendant against the plaintiff either before or after the filing of suit. But this is important matter. But before the defendant has delivered his defense, delivered this means filing his written text, not the evidence, or before the time limited for delivering his defense, it is either 30 days or 90 days, has expired, whether such counterclaim is in the nature of a claim or damages or not, provided that such counterclaim shall not exceed the pecuniary limit, judicial court. Such counterclaim shall have the same effect of a cross suit, so and so, enable to court to pronounce final judgment both on the original claim and the counterclaim. The plaintiff shall be at liberty to file a written statement in answer counterclaim to the counterclaim shall be treated as a plain. So this is the law provides by the order 8 rule 6A that it is the till the date time prescribed for the filing of the WS written statement, that is either 30 or 90 days. And the Honorable Apex Court held Honorable Apex Court held, my lord. May I read paragraph 24? That it is, I will read, my lord, before that it is the, if it is the counterclaim can also be filed after the WS, filing WS, but it should be before the issues are framed. In this judgment, that it can be filed after WS, but before the issues are framed. In this case, my lord, this when the WS filed and when the issue is framed, that may be noted, my lord. The WS is filed on 25/1/24. It's important, my
WS file
25/1/2024. And issues framed on 26/2/2024. 26 February 24, and counterclaim filed on 26/7/24. 26 July 2024. These 3 dates are important for deciding the issue. When the WS filed, when the issues framed, and when the counterclaim filed. So may I read paragraph 24? It may be page number 9. I have marked the page number 9. Paragraph 24. Defendant number 2 filed the counterclaim after issues were framed. The Lordship got. It is true that issues were framed on 12/2/19 and the application for counterclaim was filed almost 2 years thereafter, on 26/7/21. For our purpose, it is sufficient to refer to the guiding principle for determining the time frame for filing the counterclaim, succinctly articulated in the judgment of the Ashok Kumar Supra. The relevant portions of the judgment, the time limitation for filing of the counterclaim is not explicitly provided by the legislature. Rather, only limitation as to the accrual of the cause of action is provided. As noted in the above precedents, further complications stem from the fact that there is a possibility of amending the written statement. However, we can state that the right to file a counterclaim in a suit is explicitly limited by the embargo provided for the accrual of the cause of action under Order 8 Rule 6A. Having said so, this does not mean that counterclaim can be filed at any time after filing of the written statement. As counterclaim is treated to be plain, generally it needs to first of all be compliant with the limitation provided under the Limitation Act, as the time barred suits cannot be entertained under a guise of the counterclaim just because of the fact that the cause of action arose as per parameters of Order 8 Rule 6A. As discussed by us in the preceding paragraph, the whole purpose of the procedural law is to ensure that the legal process is made more effective in the process of delivering substantial justice. Particularly, the purpose of introducing Rule 6A in Order 8 CPC is to avoid multiplicity of proceedings by driving the parties to file separate suit and see that the dispute between the parties is decided finally. If the provision is interpreted in such a way to allow delayed filing of the counterclaim, the provision itself becomes redundant, and the purpose for which the amendment is made will be defeated, and ultimately it leads to flagrant miscarriage of justice. At the same time, there cannot be rigid and hyper-technical approach that the provision stipulates that the counterclaim has to be filed along with the written statement, and beyond that, the court has no power. The court, taking into consideration the reasons stated in the support of the counterclaim, should adopt a balanced approach, keeping in mind the object behind the amendment and subserve the ends of justice. There cannot be any hard and fast rule to say that the particular time of the counterclaim has to be filed by curtailing the discretion conferred on the courts. The trial court has to exercise the discretion judiciously and come to a definite conclusion that by allowing the counterclaim no prejudice is caused to the opposite party, process is not unduly delayed, and the same is in the best interest of justice and as per the object so to be achieved through the amendment. But this is important. But however, we are of the considered opinion that the defendant cannot be permitted to file counterclaim after the issues are framed and after the suit has proceeded substantially. In this case, the evidence of the plaintiff evidence already closed. This is the stage of defense evidence. it would defeat the cause of justice and be detrimental to the principle of speedy justice as enshrined and objects and reasons, particularly amended CPC. Now, paragraph 21, there are some guidelines prescribed by the Honorable Apex Court, some instances regarding the period of delay, my lord, the prescribed limitation period, reasons for delay, defendant's assertion of his right, similar cause of action, cost of litigation, injustice, abuse of process, prejudice of opposite party, so and so. Like paragraph 25, my lord, it is also important to note that defendant number 2 is seeking specific performance of an amendment agreement, so and so, which provided execution of the sale deed when the 12 month, within 12 months. Defendant number 2 did not take any action in any event. The next course of action to seek execution of the sale deed arose immediately after January so and so, when the appellant plaintiff instituted a suit seeking annulment of so-called agreement to sell. The defendant number 2 did nothing. Only after the death of the vendor, October so and so, and after framing of the issues, February 19, that the defendant decided to file application after 9 years. Paragraph 27, my lord. In view of the above, we are of the opinion that High Court committed an error in reversing the judgment of the trial court by permitting defendant number 2 to file counterclaim against defendant 1 and not against the plaintiff. We therefore allow the appeal so and so, and the High Court judgment was set aside. The High Court has allowed, my lord. It was filed after the issues were framed. So, this is the latest Apex Court judgments, my lord. It is reported in the AIR and INSC, September 2025. So as per this Honorable Apex Court judgment, this division fee is devoid of merit because it is admittedly the counterclaim is filed after the issues were framed. After about 5 months of the issues were framed and the proceeding has substantially proceeded. It is at the stage of the defense evidence at this stage. So if the counterclaim filed, then the process will be again from the filing of the WS by the plaintiff. Then again, so will be the object of the legislature for the speedy trial. It will be, my lord.
What do you want to say in regards to cause of action as per the counterclaim?
Cause of action is after the framing of issues in this case, my lord. So that as per the judgment of the Honorable Apex Court, it cannot be permitted after the issues are framed. This judgment. And whatever other regarding the schedule property or quantity of property, that is already there in their WS. And if regarding the quantity or any, my friend has submitted that we have not put any boundary in our plane, but there is specific boundaries in the schedules of our plane, and there is our purchase land. So regarding anything there, they could have approved for amendment of the my lord WS at the earliest stage. So this is a completely a question of law, your lordship, and the law is against the petitioner in this case for granting the counterclaim.
Lord, the counterclaim was filed, Lordship, before commencement of the evidence. Before commencement of the evidence. And I have also stated, Lordship, given a judgment of this Apex Court, Lordship, where Lordship counterclaim was accepted even after framing of Lordship charges. So, harming of issues, Lordship. So, Lordship, in exceptional circumstances, Lordship, even after framing of the issues, Lordship, the counterclaim can be accepted, Lordship. But the condition is, if the Lordship peruse the counterclaim, Lordship, petition, Lordship, there are two causes. I have already stated there are two causes of action, Lordship. One is, Lordship, it is admittedly it is after WS, Lordship, but the another is, Lordship, at the time of filing of the at the time of filing of their claim. So and when they have filed this title suit, Lordship, at that time this cause of action arose, Lordship. This 22 bigas of land which is purchased, they have falsely included in their Lordship. So, but Lordship, considering this aspect, Lordship, the learned trial court would have lordship researchibly considered this petition lot counterclaim.
My lord, regarding this another cause of action at the time of filing the claim. So if it is at the time of filing the claim, then where is the explanation of delay, my lord? Then overall apex court, I have submitted the judgment.
No, as per the counterclaim, the cause of action arose on 24,
27,
27-4.
27-4 issues framed, yes. Before that,
No. As per the counterclaim, the cause of
27-4.
action
27-4 is the cause of action that I have trespassed the land. That is the cause of action day. But my friend is submitting that at the time of filing my plaintiff, there was some cause of action. If that was so, then where is the explanation of delay? There is no explanation of delay. It is a 2023 title suit. There is nothing in the counterclaim. If it was at the time of filing the plaint was filed in the year of 2023.
And it is
So there is nothing.
And the
Apex court
filing-
held that there should be a delay is also to be considered.
And the filing of the lordship counterclaim was not for delay lordship. It is lordship. The framing of charge was 26-2, and the counterclaim was filed on 26-7. Lordship only few months. Lordship.
Yeah.
My lord, only paragraph 10, 15, 16, and 17 of the impugned judgment, I will impugned judgment. Yes, trial court judgment, impugned judgment. Yes, page 95. There are apex court judgment is cited, for which I have appeasement judgment is cited page number 95 in the impugned order. Impugned order. Yeah. So what I have submitted, my lord, that is mentioned already in the impugned order. So that may be, my lord, regarding Mohesh Govind Trivedi, page 95. Page 95. My citation is another. Trial court cited page 95. Page 95. Yes, madam. Mohesh Govindji. That is regarding, my lord, the cause of action should be before the, my lord, filing of the WS. And it should not be allowed after the framing of issues. Whatever I have submitted, that is the learned trial court mentioned there.
As per the WS, as per their counterclaim, their cause of action is subsequent to their filing of the WS. In
Yes.
that regard, what do you want to submit? Because it is an admitted
Yes,
fact
yes.
that the cause of action as per the counterclaim arises after filing of the
Yes.
WS
Yes, that is
or after filing of your case, whatever.
Yes, that is my submission that it is a law barred. in accepting the counterclaim after the issues are framed is barred if the cause of action subsequently arose after WS. That is my submission. In this case, the cause of action after WS and the counterclaim is filed also after issues are framed. The trial court referred these two judgments. Another judgment is paragraph 17, my lord. Paragraph 10, that after filing of the issues, counterclaim cannot be accepted. It is the
No, that is the stage of acceptance. I'm not in there.
Yeah.
I'm asking about the cause of action.
Yeah.
You have submitted it after framing of issues. Generally, it should not be accepted.
Yeah.
Maybe under other circumstances,
Yeah.
but generally, it shouldn't be
Yeah.
accepted after framing of the issues because the issues are being framed on those
Already.
pleadings which were before the court.
Yeah.
Now, I'm on that cause of action. Regarding the cause of action from here, his counterclaim, it is seen that the counterclaim, as per the counterclaim, the cause of action arose after the
WS.
filing of the
WS. Yes. So my submission is that as per judgments of the apex court, that cause of action should be before filing the WS.
So where from you're saying that's
Yeah,
what I'm asking.
yes, my lord. That is, my lord. It is in this Mohesh Rubenji is mentioned.
Where? Mahesh.
My lord, yes, my lord. Para 10. The learned response, so the Honorable Apex Court has held that the defendant cannot be permitted to file counterclaim after the issues of frame and after the suit has proceeded substantially, and that it would defeat the cause of justice and to be determined to the principle of speedy justice as enshrined in the object and reason particular to the Code of Civil Procedure. Now, paragraph number, my lord, paragraph number 15. Thus, the cause of action for filing the counterclaim must accrue prior to the filing of a written statement by the defendant, and there admittedly the defendants have filed their written statement on so and so, and thus the cause of action accrues in the instance after delivery of defense by the defendant petitioner. Moreover, as held by the Honorable Supreme Court of India in the case of Mohesh Govinji, the Honorable Apex Court has listed some factors which are considered while considering the counterclaim. My lord, period of delay, number 1. Number 2, prescribed limitation period of cause of action period, reasons for delay, defense assertion to right, similarly of cause of action between main suit and the counterclaim, cost of litigation, injustice and abuse of process, prejudice to the opposite party, facts and circumstances of the case, and in any case, not after framing of issue. Now, my lord, paragraph number 17. That in the above referred case of Mohesh Govindi, region so and so, and in the case of Ashok Kumar Kalra, 2022 SCC so and so, I am of the considered opinion that counterclaim can be accepted after filing of written statement till framing of issues, and in exceptional circumstances, it can be accepted before commencement of recording of plaintiff's evidence, but the cause of action for the counterclaim must accrue prior to filing of written statement. It is at present 22 SCC 394, Ashok Kumar Kalra. So, this is my
In my case, Lordship, the cause of action is twofold. Lordship, twofold, Lordship. One is acute immediately after filing of the title suit, Lordship, and second is admittedly it is after filing of the WS, but it is interlinked with the first one. In my grounds, Lordship, I have stated it. And in your Lordship will find the paragraph 4 of the counterclaim, which is written, Lordship, paragraph 4, page 88. That paragraph 4, page 88, Lordship, the plaintiff purchased land. Yes, sir, page 88, Lord. Paragraph 4. The plaintiff purchased land from different Dags of Pata number 12, 200, except Dag number 12, and only 2 bighas land from Dag number, but plaintiff in their petition falsely included Dag number 725 of the suit Pata, wherein they have no purchase in Dag number 725. In Dag number 725 of the suit Pata, the predecessor of defendant number 1 to 5 was the owner of 20 bighas of land, and in tag number 719, Jagannath Singh was the owner of 5 bighas, 10 katar land, and also out of which 3 bighas, 4 katar Kuch and katak land sold in favor of the plaintiff. At the time of sale of land in their tags, the present suit schedule land belonging to the land of tag number 725 and 719, which is belong to defendant number 1 to 5. The plaintiff falsely claiming the land of tag number 725 and 719, upon which they have no purchase. They, on the strength of purchase tags of other tags, deeds of other tags, trying to grab the inherited interest of Jagdambar transfer of the defendant number 1 to 5 by misappropriating the facts before this honorable court. This is also one of, it is the main lordship counterclaim partner.
My lord, regarding my friend's submission, my lord, kindly refer to paragraph number 6, page number 66, WS paragraph. The same is already there in the WS, page number 66. Page number 66, paragraph number 23. This is the dicto, my lord, of the WS, my paragraph 23 of the WS, and my then read paragraph 4 of the counterclaim. Already the plea is taken in WS. How it becomes a cause of action that was prior to filing in the WS? What my friend has read, the same is already in the WS, paragraph 23. How it can be a new cause of action for filing a counterclaim? Okay. Obliged.
Wait, please, Lordship. I mean, dismissal of my land grabbing case, my lord, is the subject matter of this CRP, my lord. Lordship, service is not complete, 1 minute, but a TCR has come, and my lord, there is a TCR has come. My lord, for respondent number 1 has appeared, my lord, 2 and 3 services have added, my lord.
Yes, Lordship, I am for respondent number 1. However, we have not received the copy of the IA.
We'll furnish it today, my lord.
Yes, Your.
I'm for 4 and 5.
2 and 3 left. We have taken steps in one behalf of 2 and 3.
My lord, the next day, has not reached the court. Before it, the case was dismissed. So that may be a relevant point and it may be remanded back the next day. Because the circle, without the circumstantial report, how can the court decide? There's the court is saying that they did not take the adequate steps. So that they must give in writing that they should.
We have taken steps, my lord. We have given in the
That
petition
they-
also. We have taken steps of that matter.
Thing, man. And this is it will go on delaying otherwise. Go on delaying, and the purpose of the act will be defeated. It goes on delaying, delay.
Well, Lordship. Lordship, that is. No, that has been stayed, my lord. That part of the order has been stayed, Lordship. Lordship can see order dated 21/11/2025, my lord. 11/25 passed by this honorable court, my lord. Considering the contention raised by the petition in the application, the impugn order stayed, my lord. To that extent, it has been stayed, my lord. Only question that my letter has pointed out, my lord,
that we have taken a step to call for a report of the circle office. Without the report, the learned court had disposed of the matter.
And my lord, my personal experience is that when somebody has a land adjacent to a plot of land, this habit of encroaching is very common. That is why it be taken seriously, because it would increase our work later on. So there will be a police case and there will be endless. So without the circumstantial report, a case should not have been written.
M. Das.
PCR has been received. Lordship, only thing that they're encroaching on our land, my lord. So Lordship may take it upon a fixed date, my lord. Lordship may take it upon a fixed date, my lord. This matter.
The state of Assam part the respondents 4 and 5.
Already 4 and 5. We will try to take steps in addition to that. Lordship, 23rd or 24th of February, if Lordship can, my lord. Lordship, 5th of March. No, my lord, I will not be available, Lordship. Then later on, 11th of March, 10th of March, my lord. 10th of March. 10th. I'm obliged, Lord.
My pleasure, Lordship. Lordship, may kindly peruse office order dated 3/2/2026. As per that office note, my lord, the service of notice upon respond number 1 is complete. 2, 3 is also as per the postal receipt complete, but 4 expired. But today morning when I perused the case record and only came to know about this, so I have to take instruction from my client regarding that respondent 4.
I'm respondent number 1. Yes.
So I have instructions to appear on behalf of 3 and Wakalat Nama. I may be.
No information.
TCR receipt. For state, this is already we on interim. There is an interim order.
Ardas.
Yes, in Lordship.
Sometime may be granted. Respondent number 3 is out of state.
Respondent number 3?
3.
He is for
I'm
3,
for
my
three,
lord.
I'm for
He is for 3.
You're for 3. Oh,
Three.
sorry. 3. Yeah. Needs some time to file his Bakarat number, as respondent number 3 is out of stage present. Further, the services also seems to be completed on the respondent number 2, that no one has represented, but no one is represented. Mr. Borthaku further submitted that after perusal of the case record today, he came to know that the respondent number 4 has already expired. Accordingly, he submitted that he as to if he will take instructions from the appellant, and accordingly file the interlocutory application for substitution of the legal years, if any. in view of this, we received a copy, na? DCR quite late. DCR has already been received. List the matter accordingly in order column. How many weeks you need here?
3 weeks maybe. I have to take instruction regarding the legal error of the board.
Enabling the appellant to take instructions and to file the interlocutory application if so advised. List after 3 weeks as an due at least. I interim is operating.
Yes, yeah, till today.
I today heard Mr. P.P. Potter, the learned counsel for the applicants, and also heard the learned counsel for the respondents. Let the interim be continued till next episode. List the present I along with the RSA 215 of 2015 to try the as on a date.
Oblige, Lord.
Please, Your Lordship. This matter awaits service report as per office note dated.
Service report is awaited for whom? For all the respondents?
Respondent number 1, 2, and 3.
1, 2.
An interim is there, interim to be continued.
You are MS?
S. Ajmi.
S?
Ajmi.
Azmi.
AJMI.
Part Mr. S. Ajmi, the learned counsel for the petition from the office note dated 3/2/2026. It is seen that the services awaited for the respond number 1, 2, and 3. Let the service be awaited till next day. List the matter after 3 weeks as on a date to effect by the registry. Interim be continued till next week.
Blessed.
May I please, Lordship? Cross appeal for enhancement, Lordship. Cross appeal for enhancement, Lordship.
What do you have to say?
They have filed a cross appeal, Lordship. So that is notice has to go in that one.
Acha, cross objection you have. For enhancement.
Lordship.
In the cross objection, you are for the whom?
For the insurance company, Lordship.
That is the respondent.
Respondent
paper.
number 1.
1, I think.
Not 1.
1.
Um,
Huh? No, not
how have they
not
filed?
1. Oh, here too they are not the party. In your cross objection, see?
Lordship, it is totally wrong.
Huh.
Because they have made us the party and then versus so and so.
That is the cost title is to be amended. I think. Yeah.
Yes.
Lordship, after some time, my senior coming in. After some time, Lordship.
Why? After some time, now see, prima facie, I mean, probably in the record itself, it is same. Now see, your cross objection is basically you are saying for enhancement, isn't it? So enhancement is definitely, I think it will be against the company. For the company, because appeal is also filed by the company. Then, but you have not made party. Simple amendment is required. Okay, if you have any confusion, we are time being keeping.
My pleasure. My lord, I am for the wife, my lord. My lord, husband has
You
filed.
filed your transfer?
I have filed transfer. My lord, husband has filed my lord divorce petition. My
Acha, so you have
Kamrup.
filed the transfer.
I have filed. My lord, may I think, my lord, it is a my lord a fit case for mediation hearing, my lord. I court, my lord.
My lord, let a attempt be made, my lord. My lord,
We have no objection.
my lord,
So the question is that if it is suppose transferred, then it is
My lord-
only the transfer matter
yes, my lord.
because divorce or the other thing is not before this court. So mediation to what extent? Only for the transfer.
My lord,
And transfer definitely it has to be looked into whether the jurisdictional issues are there, the convenience of the parties are there. That these are the questions under 24 has to be discussed or decided. Now, whether it will be possible on the part of the mediator to discuss or decide that.
My lord, I think, my lord, I have taken consent, my lord. My lord, if the matter goes to mediation, my lord, entire matter will be. My
The
lord,
entire matter is not before us, not before the High Court. That's what I'm saying. Your matter is not before us. Divorce is not before the High Court. It is still before the principal judge, or I don't know. Maybe
In a matrimonial dispute, Lordship.
now, obviously,
Yes,
matrimonial
matrimonial
dispute is a very fit case for.
Yes, yes.
We are not denying it,
Yes.
but the case is not before us. That's what I'm saying.
my-
It is only the transfer petition.
my submission before you, lordship, my lord, since my lord, several cases are pending before my lord Nalbari court, my lord. My lord, one case has been filed by husband hearing for divorce.
I
my
can understand there are some reasons for which you have filed the petition for transfer, isn't it? So I'm not on that. We definitely will feel, I mean, good if the case is amicably settled between the husband and wife. It is our first option. Now, my question is, it is not the case.
My
It
lord,
is only the transfer. That
my lord.
you take instruction, otherwise you withdraw. Suppose if there is a possibility, you can very well approach the learned court of Nalbari also with an application that the matter has already been settled. If it is settled, if it is there, probability is there.
Then, my lord,
Outside settlement, or you can even post it on 14th of March. Put for the most probably the local will be held
my lord.
in every court or every district. It will be held, including the High Court. So you can approach the learned the district judge, court of district judge,
And family
the
court.
petition that it may be listed before the local. But prior to that, you have to withdraw this one because otherwise dependency case of dependency of this will be here. So I do not pass any order. You just take instruction.
My lord.
On the basis of your instruction, if it can be withdrawn, just withdraw it.
My
File
lord, I will
petition
take
so that it
instruction.
can be placed before local.
My lord, if possible, my lord, out of the court, my lord, my lord, give instruction for settling the matter out of the court. My lord, I will take instruction, my lord.
Lordship,
Just take instruction.
I have one submission regarding the matrimonial dispute. Other maintenance case, the domestic violence case, and the police case also 498 also between the parties. So all in the mediation center, both the parties can settle the matter. Although it is a transfer petition, in the mediation has this ample power role to settle the matrimonial dispute.
Now, see, I am not on there.
Yes.
I am. These are our mediation drive is also
Yes,
going
yes,
on.
Yes.
And nationwide, our mediation drive. I am not on there. I am on the only the question that the
Yes.
divorce is not before us. That is the only issue. Otherwise, I am ready. If divorce is before us, then definitely it is a fit case to go for the mediation.
Yes.
No, there is no dispute at all because we are insisting the matrimonial, especially the matrimonial affairs to go for the settlement before mediation. That is okay. Now, this is only the transfer.
Transfer
That's what I'm
case.
saying.
That's
It is
fine.
not the case, only the transfer. So he, at the best, he can seek instructions from his client. Better to withdraw this one if there is a possibility of any settlement. That's what I'm saying. It may not be disposed on merit. It is only will be disposed upon withdrawal or only. Simple withdrawal will be there. You take just instruction.
My lord.
Fixing a very short date.
Because stay is there.
But
There is stay is there, so short date.
and in the meantime, you can also very well approach before the learned district judge Nalbari with a prayer that matter may be fixed for local. So that can also be said.
That this is the pending before the family court Kamruk.
Kamruk, my lord.
Oh, Kamruk.
My lord, I am seeking transfer from Kamrup to Nalbari.
Oh, acha, presently it is in Kamruk.
Yes,
Kamruk.
my lord.
Oh,
in Guwahati.
Short data review. The request made by learned principal state the matter.
After 10 days.
It can be 1-3.
My lord.
We're listing it on 1-3. Just inform us if you
My
take
lord.
the instructions. or otherwise it may be heard.
My lord, exactly.
Sir, 13 is some difficulties there.
Okay, then
13.
yes, tell us.
Can be 11.
On 11?
11.
My lord,
Can be okay.
11.
obliged to.
Yes.
May I please your lordship, my lord, as per office note dated 20/11/25, service has not been completed.
Services, how many respondents? Sole respondents or
My lord,
there are
seven.
respondents? Nah? Oh, there are as many as 8 respondents.
Yes. 8.
Heard you are MS? You are MS? Also good name.
Chaudhary.
Huh?
And Chaudhary.
And Chaudhary. Heard MS and Chaudhary. You are appearing for anyone? You are appearing for whom?
Emma.
And Chaudhary appearing on behalf of Mr. M. Ahmed and the Constituent Office note dated 20/11/2025. It seems that neither the AD card nor the answer notice is returned. The respondents, let the service be awaited till next date of listing. Please do matter accordingly after 3 weeks. It will be listed after 3 weeks.
Look, I have got that.
Yes, simple was
I'll,
there.
I'll rectify it. Your lordship may issue notice by tomorrow. I will replace this man.
Nowadays, the amendment is required not by hand, not even handwriting.
Then
Handwritten.
lordship made an observation that I'll replace this page lordship page number.
No, no,
What
whatever you do, before registry only you have to do. Make a simple amendment, you draw cost title because the name of the company is not there.
Really, but
That
let's
is-
take that only that order and let it come next week. He is in a
Yes,
hurry, I suppose. It
No.
can come next week. He can do it within 2 days.
That means I have to file IA.
No, no,
No.
We must know cost title or
Yes,
amendment.
lordship. I'll submit that
Pass the
before the
order.
registry.
Yes,
Lordship.
Heard Mr. M. done it not for the CO2 CO 22 oblique. So and so. Miss Arlington. For the apple. This cross objection has been filed. Yes, by the you are the otherwise claimant, na? Claimant respondent, na?
Yes, only relevant.
Claimant.
Claimant,
Ah.
yes, but
Claimant.
Claimant
respondent. Claimant. For advancement of the quantum of petition filed in connection with MSc appeal number 285. But on perusal of the record, it is seen that the appellant of the insurance company is not made party respondent in this case. in this case. In that context, Mr. Khan, the learned commissioners, the respondent submitted, they will make necessary amendments of the cost title of the petition. To in view of this, the petitioner is hereby directed to amend the cost title of the petition by inserting name of the company, respondent of the company as a party respondent. After correction, the same, or after correction of the amendment of the same, the matter will be placed for list sorted by one.
Earlier pledge.
Public.
Or hearing item.
Ma'am, you are for the respondent?
I'm here the respondent, my lord.
Appellant?
Appellant, my lord, appellant advocate, DC can expire long back, my lord. Long back.
Expired?
Expire long back, my lord.
No, no, who expired?
Yes, ma'am.
Oh.
So the cases can earlier also. And I
Yeah.
from the end of court. No new advocate has been engaged.
Yeah, no. Definitely in that case, we'll ask the registry to issue notice. Otherwise, there are no one is represented.
Yes, yes.
But Mr. BP Sinha, the learned counsel, appealing for the respondent. None appears on call to represent the appellant, and it is submitted by Mr. Sinha that the engaged counsel has already expired long back. Stop in view of this, expired in view of this, registry is hereby directed to issue notice to the appellant to engage the counsel on their behalf. The registry will do the need list the matter accordingly after 4 weeks as an agent. Is there any interim is operating? No. Okay, listing it after 4 weeks. Let's see if they appears. Otherwise,
May please. My senior legs in port number 23. Need password for time being.
now see, timing may create a problem because what I'm saying, because I'm saying it is about to be one. If I start the another hearing, your matter may not reach. That apart, we are sitting only up to 3:15 because of the that reference. So better to take a date, I think so, because it may not reach if the other matters, we start the other matter.
My
Because
lord,
only 1 hour will get only 1 hour, 2 to 3. So 1 hour, within 1 hour, 2, 3, 4 matters cannot be heard. So the one matter will be heard at that matter. So if it is a senior is in legs in other courts, so better to take, I think, adjournment. Otherwise, I cannot say.
Short that may be accommodated.
It is of 2010 matters. Na?
my lord, actually there is some confusion regarding service of notice to respondents 4, 5, and 6. There was paper publication and all that. Orders were there, very old order. But even today, I don't see anybody picking up.
You are as a government, who are
I am for 1 and 2.
1 and 2.
Because there, if my lord looks at the records, there was a lot of confusion for about many years regarding service of notice to the 453, including there was an order to give a paper advertisement. So even now they have not come today also they are not. So in any case, the case will not be possible.
See, there is
I'm only for
one,
state.
just a second, one order of the office notice, one office notice there on 2/11/2011. Wherein it is in there is in the office note as well as the Lojama court order. In the office note as well as so and so, in spite of order of Lojama court on 7/6/2011 at 28/09/2011. The applicant has not taken any steps of notice. 4, 5, 6. Yeah. So you have not taken steps. Issue notes of the court.
Because what is the point, my lord? That is a very serious thing.
Huh?
Too many years.
itu হচ্ছে 2 একর হচ্ছে 25 ডগ has been related by comments for that sentence. So your notice is not yet served.
So my lord will send it to Lozima.
Lozima report is there.
So what there is no option, my lord.
This record was put up before the Lozima court, and the Lozima court says that though it is put up before the Lozima court, but the question is that they have not taken any steps for issuing notice to 4, 5, and 6. So
Will
till
take
now there
place.
is no steps at all. Now
Will-
see, the matter is of 2010. So why it is so
16 years, man.
16 years old matter?
Will take, my lord.
So my lord may just record a last chance is given. After that, it will have to be dismissed. Because the two courts, the two lower court decisions
Concurrent.
are concurrent and against them. So, and my lord, the reason is odd, my lord. They said that our officers have refused to register their names in the red line record. Now that cannot be. How can that be?
Your good name?
Eldeka.
Heart, Mr. Eldeka. You are appearing for M. Datta?
M. Datta.
Appearing on behalf of Mr. Done for the app. And also heart, Mr. Sajid Learned comment and appearing for the respond number 1. This case is fixed for hearing today, and the and it is of 220. It is a matter of 2010. But surprisingly, from the office note dated 2/11/2011, it is seen that till date the applicant has not taken any steps for the respondent number 4, 5, and 6, in spite of several direction by the court. In view of this, the applicant is hereby directed to take immediate steps within 2/3 days to issue notice to the respondent number 4, 5, and 6 through speed post and usual process. The matter be accordingly listed after 3 weeks as on a date to be fixed by the registry. But it is strict direction for the header, strictly directed to take steps.
And my lord, what my lord found in my lord High Court's record is telling with our record that service has not been. We also have some paper. That is the high.
Admittedly, service is not yet there. Admitted.
One order is there, A.K. Goswami's order, 2012.
Oblast. May I please, your lordship? So this is personal difficulty. The second,
Your
it will be fixed on a particular date. It would have agreed on 13th of February at 2 p.m.
MS Chaudhary will not agree.
Lordship, I have no objection. He has some personal difficulty, Lordship. Second half, he is ready for the first half.
So I
Go to second half only.
Yes, Lordship.
At a request made by the Planet Council for the response, the matter is that which MS R. Chaudhary, the Planet Council for the applicant, so yes.
Only our
This is of 2016 matter.
Lordship, only our prayer before your Lordship to fix this matter at 2 p.m. on 13th.
1/3.
Yes, Lordship.
1/3 is Friday. 2 p.m. Let it be in any no. Hearing day need to hearing day hearing day one
Hearing day, Lordship.
Friday with it. Friday need to Monday by advance of 2 p.m. Monday to no. Kun Monday? Monday. Fix or Monday. Hearing after 2 p.m. hearing.
Then can it be on 16, Lordship?
16.
It's a Monday, Lordship.
18 is what? Goodbye. 18 is Wednesday. It is not hearing day, but your particular matter will be fixed at 2 p.m. Okay. It is not a hearing day. I'm just saying it is not a hearing day, but your matter will be
Before that, Lordship, any date. Today is 5th, Lordship. So
it won't have dates.
9 day, there are so many RSS already fixed, 9th and 10th. Can it be on 10th then, Lordship? It's a hearing date.
Hearing day is almost full.
Lordship.
That's why I'm saying that it may not be a hearing day, so that it can be fixed at 2 p.m. That's what I'm saying. So in that case, you take a date after you are busy.
11th, Lordship. 11. This is Wednesday.
11 may not be possible. Kiba happening chronic one. Goodbye. Okay, then on 11 at 2 p.m.
Lordship.
11 at 2 p.m. We're listing it.
Lordship. Obliged. sir. 11.
Nineteen. Then appears for the appellate as well as respondent. The matter state after 3 weeks has made it due to 48. "21, you are for the respondent. You are for the petition.
Yes, my lord. Basically, for quantum, my lord, for enhancement, basically, my lord, we have filed this appeal as the trial court did not consider the income tax return. The national income was taken as a 4,500, even though we had exhibited one documents, page number 23 to 25, my lord.
Lordship, can I just submit something here? Lordship, preliminary objection to the appeal is that the owner of both the vehicles are not made party. So how can we indemnify if any increase or decrease, whatever, Lordship, they have not made owner of both the vehicles. Two insurance company are there. He is for one. I'm for one. So, Lordship, the appeal itself is not made. Remove.
My lord, a trial court has passed the judgment and directed the respondent of 1 and 2 satisfy the awarded amount passed by the trial court. Accordingly, the respondent of 1 and 2 is already satisfied the award. And my lord, so whatever the documents regarding the vehicle and driving license as well as it was submitted and that was not disputed. So the liability already destined to the respondent of 1 and 2. There is no requirement or no necessary the owner and driver in this appeal, my lord.
Let him show some judgment, Lordship. Because in the trial court, owner, driver, they filed the written statement.
See, you are rightly submitted that the liability was on 1 and 2, that is the two company.
Yes.
We can understand that.
Not
But
1
you
and 2,
cannot,
4 and
but you cannot avoid to imputing them as a party. Subsequently, you may say they may not be a necessary party,
Yes, my lord.
but impeachment is to necessary. Otherwise, you can submit as MS Mozumdar is submitted. You can submit any judgment in that.
Yes, Lordship.
Or you
If
can
he can show, I will accept. No issue with that. But he has to show some, because preliminary, I'm raising that issue before hearing takes place, because full-fledged hearing will be done and then I will talk about maintainability. That will not be correct.
Now, see, the question is liability is or the companies were directed to satisfy the award.
Yes, my lord.
That is not disputed at all.
Yes.
It is admitted.
Yes.
But the question is to whom will be indemnified? It is only the owner.
Already they have satisfied.
No,
They have paid.
no, it is the owner only. Owner only, even if suppose enhancement amount is there, in that case also, it is the owner who will be indemnified by the company because of that policy.
Yes,
That is the case.
Yes.
That's what I think that most probably in the long run, if you can submit that they may not be necessary party, but the question is the making party as a respondent most probably will be required, or if we can hear to that effect in any other day.
My lord,
If you are ready, then it's okay.
Let him show some citation that.
My lord, in some other cases in appeal, the owner and driver also strike out. There are the analogous
Obviously,
cases.
we do understand that there are several orders.
Yes.
Even in fact, this court had also
Yes.
passed many
Yes,
orders, but the impeachment is necessary. Subsequently, you may say at your risk that maybe strike out. At your own risk, the driver names of the driver and owner may be strike out.
Lordship, otherwise, he can do the hearing at his own risk. He is doing. We will be submitting our part of the hearing. Ultimately, Lordship will decide whether insurance company can indemnify. That point will come. He can do the final hearing. here.
Yes, my lord,
That is-
that will be better because of indemnity,
Because
all the respondents.
Otherwise,
It
it
will-
has to show a judgment because preliminary objection I'm raising. That the how will we indemnify?
Here is, my lord, some two respondents, owner and driver, also ex parte. So as per order 14 CPC.
No, no,
No,
they are not in there.
Your Lordship, that
It's
is
not on there.
judgment.
Expert is okay. Expert is no issue.
Uh,
In it, learned before the MSCT court also or the learned member also, their case may be expert. Because they may think the insurance policy is there, so they will going to satisfy the above. That is okay.
Yes.
But they
if
file
making
written
party,
statement.
party.
They file written statement.
Or written statement?
Yes,
Yeah.
or
There is two vehicle is there. I'm saying
Right. OP number 1 and 2 owner have contested case by filing a joint written statement. And in 5 Lordship, the OP number 3, Nijan Chandra Pegu, owner of LS Jen Estilo, has filed a separate written statement. They appeared and they filed their written statement also.
They to appear then. Mr. Das, they have
One and
already
two.
appeared.
It's not ex parte. And even if ex parte, again in appeal,
You have to make part. Subsequently, your relief may not be there against them, or you may be strike out the name at your own risk. That is different thing. But you, or otherwise, you place some judgments and all. Let the matter be decided in some
My
other
lord,
day.
later one date maybe fix for hearing on completing the parties whether it's necessary. I will try to test if it is not necessary. If necessary, I will.
We heard Mr. Pierre Dust, Planet Council for the appellate, and also heard Ms. Fatima Jupiter, Planet Council for the respondent. And Mr. AJ Sakya, you are for the respond number 1 for the complaint. While at the time of argument, it is preliminary objection is raised by MS Mujumdar that the present case, the owner and driver of the vehicle, two vehicles are not with party respondent to this, and for which the case is the present appeal is not economic. Next, Mr. Das, the learned counsel for the appellant submitted that the present the respondents, the company had already satisfied the award. This is only for enhancing of the quantum of the company. Considering the submission made by students state the matter be listed according for a hearing to the point of maintainability. List. After 1 week, you insist a date, then it will go to March.
My lord,
February, we don't have any date.
Can we be fixed on 21 February?
I won't be here. I will be out of state.
No, February, you don't have date.
Oh.
Don't have any dates.
March 11.
Yes, Mojumdar, can it be? Oh, it is a Wednesday. 12 is that 12?
12. Okay. 12.
12.
Highly obliged, Lordship.
22 is also your case. Mr. Paul is not there. Paul put. Heard Mr. Pierre Das, the learned counsel for the appellate. No one has represented the respondent to the name of Mr. R.C. Paul is reflected in the court. However, for the ends of justice, let the matter be listed after 2 weeks as on a date to be fixed by the registry, directing both the parties to appear and proceed with the hearing. This time. Mr. Mahmood, you are for the respondent here,
Yes.
and for the petitioner, who is for the petitioner?
Petitioners,
Are not here.
I was sitting here. Kindly see the last order. Actually, we are suffering because in the disputed land, We have dwelling houses, injunction has been granted
RK
by the
Rama.
landed civil justice in junior division. Then they went on appeal. The order of the landed junior division judge was upheld. Then they have filed this.
No, it's okay. Where is he?
But
Mr. There are two names.
otherwise, no
There
further
are two
adjournment.
names, Mr. S.K. Roy and K. Rahman.
Kindly see the last order.
Honey, I have seen.
So we are suffering because our house is there. We are getting disturbance from them in getting entry into our house. And the Supreme Court says second revision does not lie.
It's okay. We are not going. We are not hearing the matter. We are looking for Mr. Roy or Rahman. I have seen your order, last order, wherein it is fixed today for hearing in fact. Mr. Doctor, your case has already been gone. Your order has already been
Item
passed.
number 17, my lord. That we have made a paper publication, in fact, my lord, because they were not available, my lord.
It is already gone. So next week I have listed it.
My lord.
Paper publication.
Yes.
There is no note at all.
We had to make a paper because there's
There is no note at all, and there is a note in the registry that you have not taken steps even to register post for the respondent 4, 5, and 6.
My lord, I'll to clarify that, my lord, because it was-
Okay, no, we are not going to hear the matter.
Oh, anyway.
It's of 2010 matter. So we have listed the case directing you. On that day, you just place the paper publication affidavit you have filed there in that regard.
I'll have to see, my lord.
Because affidavit is also not available in the
Okay,
record. But if it is published through any paper publication, then the affidavit also required.
Definitely.
And make a submission in regards to the steps taken by you.
So, lordship will speak to it on that?
I don't know. Yes, Mr. Mahmood, without in his presence, it matter cannot be heard. He is the appellant. I mean, the petitioner side.
We are suffering on the basis
No, no,
of this.
suffering is okay. They are not here. That's what I'm saying. Suffering is okay.
May I say one thing? I may provide the judgments of the Supreme Court. After going through the judgment, Lordship may deliver the order.
No, no. Hearing is required. They are the petitioner. Hearing is. On the last occasion also they were present. Na? It is the only occasion they are. I don't know why they are not here.
They have got the injunction and MAD.
Maybe. None appears.
Then
None appears to
kindly
call for the petition.
Tuesday next.
I heard Mr. M.U. Mohammed, the learned counsel for the response, and it is submitted. The matter is urgent. And accordingly, on the last occasion, it was fixed for hearing. However, in absence of petitioner, the matter could not be heard. And considering the submission made by Mr. Mahmood, lately Saturday. In the month of February, it is very not at all possible. Somehow at best on the 26th of February. Prior to that, we don't have any dates. 26th of
But
February.
Lordship may kindly observe, if on that day they remain absent, order will be passed.
26th of February, so and so, directing both the parties to proceed with the hearing on the next day without fail. In absence, consequential order may be